Morning students, welcome to Ekcel Academy's CSEET crash course. We at Ekcel Academy have been conducting classes for company secretary course since more than 10 years now, and we have been conducting online classes even before the start of pandemic. So if you observe our YouTube channel, or even if you have already purchased, you would know by now that we conduct classes exclusively in English. So we will have both live classes as well as the recorded classes. So if at all you want to get an idea as to the kind of classes which we conduct, I would suggest please do visit our website excelacademy.com, the link of which can be found in the description. So register there. It's of course free of cost. So find it out yourself instead of me telling you. It's better that you only discover what exactly we do. So that way you will have a better idea of what exactly we are doing. On top of that, on the website, if you register, you will get access to quizzes. Then you will get access also to mock tests. So and whatnot, notes as well. So all these will definitely help you in more than one ways to score good marks in the exam. I hope you take advantage of the same. Anyway, let's get on with the lessons for the day. So now we'll be continuing legal aptitude. I guess we were looking at Contract Act in the previous session of legal aptitude. Let's continue from there, and then we'll move to company law. See what exactly, company law, I guess. Where were we? Okay, this Contract Act is in second chapter. Okay. So we looked at section 10, I believe. Section 10, of course, talks about the essential elements of a contract. We also looked at what is a contract. Contract is nothing but agreement which is enforceable. So if it's just an agreement, then it will not become a contract unless there is that enforceability. And that enforceability comes from section 10. That is the essential elements of a contract. So that is what we have seen. And also there should be intention between the parties to the contract to create that legal relationship. If there is no such intention between the parties in the sense the ones who have entered into the contract, then it cannot be considered as a contract even though it was an agreement. For example, we have this very famous case which we discussed in the previous class, that is Balfour versus Balfour, wherein the husband and wife entered into an agreement. The husband was in Ceylon back then Ceylon was the name of Sri Lanka. Then they went back to UK, both the husband and wife. She had some ailment. Husband told her, you be here, take care of your health. I'll go back to my work in Sri Lanka. I'll send you some money every month. So far so good, but after some time he stopped sending money. Then she sued him, saying he had agreed to send me money every month. No, he has stopped after some time. The court said no, this was an agreement, but it was a domestic agreement and there was no intention between the parties to create a legal relationship. That's what the court held with respect to Balfour versus Balfour case. I would suggest, if you are interested in case laws, also take a look at merit versus merit. So that is also an interesting case. Slightly different from Balfour versus Balfour, where there it was held there was intention between the parties to create legal relationship. Then if you are interested, I would also suggest you to take a look at Jones versus Padavattan. So in this case, it is not between husband and wife, but it is between mother and daughter. So the court held in this case that it was a domestic agreement and there was no intention between the parties to create legal relationship. Two extensive cases, especially Jones versus Padavattan. If you find time, do check out those cases. You can read a lot about those two on the net. So just search for those two. So of course we looked into all this obligation, agreements which are not contracts, offer and proposal. Offer is the first thing which initiates the contract. Then you offer or make the proposal to someone, so they accept or reject it. Once they accept, then it's like lighting the matchstick to the gunpowder. You just can't take it back. Okay. So that is what we saw. Then we also looked at lapse of offer, like when exactly the offer lapses. So all that we saw in the previous class. Then we also had this revocation of offer. So when exactly you can revoke the offer. So all that we saw. Then Privity of Contract also we saw, how a stranger to the contract cannot sue. This is very important consideration. Unless there is consideration, there is no contract. So no consideration, no contract is the general rule. But of course there are exceptions. That is also very important. As to in certain cases, even without consideration, you still can go ahead with the contract. So which are those cases? So that also we have already seen. So then we looked at void agreement. Void agreement is the agreement which ceases to be a valid agreement. So that means it will no longer be a valid agreement. It may or may not have been valid agreement earlier, but now that it is considered void, it is no longer a enforceable contract. And we also looked at competency. Competency means the persons who are capable of entering into the contract. So who are the incompetent people? Someone who is mentally incapacitated, someone who has been induced into a contract by violation of their free consent. Violation of free consent means they did not on their own will enter into the contract, but instead they were coerced, or maybe due to misrepresentation, or due to fraud, or due to some other reason they were made to enter into the contract. So in such cases we say there is no free consent. And of course we also looked at competency with respect to minors. That means minors cannot enter into a contract. So lunatics, same way. That means those who are mentally incapacitated. Then those persons who are expressly disqualified from contracting or entering into a contract by any law. So they are also barred from entering into a contract. So we looked into all this in detail, so I won't get into that again. So we also looked at void and illegal agreements. What is void agreement? What is illegal agreement? So then we had look at wagering agreement, mostly like betting. So again, it is illegal. You can't have such agreements. Even if you have also, it won't be enforceable because it is void. Then discharge and termination of contracts. I don't think we have done that too. Okay, breach of contract. Okay, what is breach? We also looked into this, I believe. Breach is when one of the parties don't perform their part of the contract. That is when we say there is breach of contract. So if at all there is breach of contract, what to do? Let's look into this. Where the promisor neither performs his contract nor does he tender performance, or where the actual performance is defective, there is breach of contract. That means someone who had promised to perform, if they don't perform at all, or even if they perform, the performance is defective. Let's say someone had promised to sell you, a trader, 100 kgs of rice. So now there are two situations here. Either they did not sell at all, they did not send the item at all, or they sent only, let's say, 10 kgs, saying they have sent 100 kgs. So in both the cases, there is a breach. You either did not perform it fully, or you did not perform at all. In both the cases, we say the promisor has breached the contract. That means they have not performed it properly according to the terms of the contract. So now when does this breach take place? It may take place either at the time of contract itself. That means either at the time of performance. Let's say the due date for selling the rice is 10th of April. On 10th of April, you don't get the rice. In that case, there is breach of contract. Or what can happen is, on 8th of April only, you will get to know that that person has no intention of sending you any rice. Through various actions of that person, the promisor, you realize that you are not going to get anything from that person. So this is called anticipatory breach. Even before the actual performance. The actual performance was scheduled on April 10th. But on April 8th only, you got to know this guy is not going to send anything, because he was supposed to send you everything by 10th. On 8th, he closed his office, and in front of his office, there was a notice saying the office will be closed for next 7 days. And he's out of town. So through this action, I'm just giving you an example. Through this action, now you have realized that he's not going to perform, or you won't be able to perform basically. So now it's called anticipatory breach. Breach which you can easily anticipate. Okay, that is what it's all about. Let's look at this case law. Hochester versus De La Tour, 1853. Oh, even before the Contract Act was enacted here in India. A hired B in April. A hired B in April to act as a courier commencing employment from 1st of June. Okay. But wrote to B in May repudiating the agreement, cancelling basically. So B was hired by A in April itself, but he was supposed to start his employment by June 1st. But in May, he cancelled the contract with B. Now what did B do? B sued A for breach of contract immediately, because probably he thought, anyway, I have already got the job from June 1st, I'll be joining, so he didn't probably apply anywhere else. But now all of a sudden A cancels the contract. Now, when the matter went to the court, A said, he contended that there cannot be any breach of contract at all, because the contract was supposed to start on 1st of June. We haven't even started. So wait till 1st of June. Until then, you cannot claim any breach. Surprisingly, the court said, in fact, court was, of the view that you cannot say we'll have to wait till June 1st, where the performance was supposed to take place. We can only consider that as breach of contract, and this comes under the category of anticipatory breach. So he was entitled to sue immediately. That is the most important thing. So, and B was able to sue, and he did not wait till 1st June, because when you already know that this person is not going to honor the contract, when he has already cancelled the contract, it makes no sense to wait till the actual performance date. What's the point? There's no point at all. So as and when you get to know that this performance is not taking place as a promisee, you were entitled for the performance. Now the promisor is not performing that, so sue. So under which category? Anticipatory breach of contract. Okay. Now next, in Avery versus Bowden, A hired B ship to carry a cargo from Russia. Okay. B has a ship, A has hired it to carry cargo from Russia. Later, B repudiated the contract. The ship owner cancelled the contract. A delayed taking action, hoping B would change his mind before the performance date. Let's assume for our sake that 10th of May was the actual performance date. From 10th May, the ship was set to start its voyage towards somewhere else, taking goods from Russia. But on April 30th only, B cancelled the contract. Now, A is waiting till 10th of May to actually sue B, because that was the actual date of performance. That was his intention, A's intention. Now what happened between this date, between 30th April and 10th May, war broke out between Russia and Britain. He is from UK. He was supposed to take goods to UK. Now that there is a war between Russia and Britain, there cannot be any contract between the two nations. So in this case, A has lost his right to sue B for damages, because now he can't, because there is a war now. B, even if A sues B will say there is war. How can I perform? There cannot be any contract between warring nations. So therefore, no contract or no breach at all. So what should have A done? A should have simply not waited till the actual date of performance, but instead should have sued B immediately, as and when B cancelled the contract. At least would have got back some amount of damages. So that is what A should have done. In Frost versus Knight, the law on the subject of anticipatory breach was summed up as follows. Okay. The promisee, if he pleases, may treat the notice of intention as inoperative and await the time when the contract is to be executed. That also you can do. you already know that the other party doesn't intend to perform. You wait till the actual date of performance and then do whatever you wish to do, and then hold the other party responsible. But in that case, he keeps the contract alive for the benefit of the other party as well as his own. He remains subject to all his own obligations, liabilities under it, and enables the other party not only to complete the contract if so advised, notwithstanding his previous repudiation of it, but also to take advantage of any supervening circumstances which would justify him in declining completed. Basically, this judgment is like it's trying to give an explanation to this particular judgment. So what they're trying to tell us is, you may wait till the actual date of performance, or you may sue immediately. But in the eventuality that you decide to wait till the actual date of performance to sue the promiser, then you will be doing at your own risk, because we do not know what might happen between today and the actual date of performance. So why simply wait? When you have the chance, sue and get the damages. Okay, now that we have seen what exactly is breach of contract and when we can sue the other party based on whether it is breach or anticipatory breach, let us look at the remedies for breach. Like, what if you have suffered some breach, then what can you do? So where a contract is broken, the injured party has several courses of action open to him. So which are those? Let's look at this. Rescind the contract and refuse further performance of the contract. Rescind means you cancel the contract. I don't want to be part of this contract. So therefore, I'm going to cancel the contract. Now that you have suffered breach, what's the point of even entering into contract with such people who don't have any intention of honoring? So that is one, cancellation. So the other option which you have is sue for damages, when you can tell that I have suffered so much of damages because of your breach, so therefore I'm going to sue you. So that is also a possible outcome. Then sue for specific performance, wherein we can say you had entered into a contract. Let's say A had entered into a contract with B. A is the promisee and B is the promiser. Now B had promised to paint A's portrait, and only B can do that. Okay. Now B has refused to do that now for some reason, whatever it is. Now A can definitely ask for specific performance, meaning he can get the court to direct B, wherein the court may direct B to perform specifically what he had promised, that is to paint the portraiture of A. That is also there. Sue for an injunction. Sue for an injunction to restrain the breach of a negative term. So what you can do is you can sue. The court may injunct saying you can't do this. So that is also there. Sue on quantum merit. Sue on quantum merit means, let's say A has performed his part of the obligation, whereas B has not performed his part of the obligation. So now let's say A has already sold rice to B, but B hasn't paid any money. Now, to the extent of rice supplied by A can definitely sue on quantum merit. Based on the amount of goods sent by A, he can definitely ask B to, compensate to that extent, even though there is breach of contract. Again, the same thing has been explained here in detail. Just go through that once. Next, contract of indemnity and guarantee. Let's see what exactly it is. A contract of indemnity is a contract by which one party promises to save the other party from loss caused to him by the conduct of the promiser himself, okay, or by the conduct of any other person. So one party is promising you to save or be saved from loss caused to you by the conduct of the other party or by the promiser himself. Okay, let's look at the example. For example, A contracts to indemnify B. A has contracted to indemnify B against the consequences of any proceedings. So A is telling B, you don't have to worry about any proceedings which C may take against you. Who is telling this to whom? A is telling this to B. A tells B, you don't worry about what C may or may not do. I am the guarantee. So in this case, A is trying to save B, that is the other party, from loss caused to B by the conduct of A or by any other person. In this case, any other person being C. So that is what it is. This contract of indemnity may be express or implied. Any contract can be express or implied. The later may be inferred from the circumstances of a particular. Of course, that you will get to know anyway from the circumstance. It's not unique to only indemnity contract. Any contract as such can be implied, and you will get to know through the terms or circumstances. The person who promises to indemnify or make good the loss is called indemnifier. In our example, the indemnifier was A, and the person whose loss is made good is called the indemnified. So it is indemnifier, the one who is making good the loss, and the indemnified whose loss is made good. So in our example, that was B. A contract of insurance is an example of contract of indemnity. So in case of insurance, what exactly happens? The insurer is promising you to make good the loss suffered on account of any possible loss caused to you due to various reasons. For example, if you have vehicle insurance, so the insurer, the company which is giving you the insurance, is telling you, we will indemnify you against any possible loss in future. Future in the sense that will be valid for the duration of the insurance premium. So now insurance company is indemnifier and the policy holder would be the indemnified. So that is the indemnity guarantee. But this is only applicable in English law. Okay. Under the Indian Contract Act, the contract of indemnity is restricted to such cases only where the loss promised to be reimbursed is caused by the conduct of the promisee or any other person. So that means it is restricted to the loss caused by people, or rather persons. Let us slightly widen the definition. The loss caused by events or accidents which do not depend on the conduct of any person cannot be sought to be reimbursed under a contract of indemnity. That means if this loss is caused due to any natural calamity or some other reason, no. In that case, there is no question of indemnity. It should be man-made. Whatever is the calamity, it should be man-made. Only then we can say that in this case we will indemnify. So otherwise, what happens in Indian Contract Act? That contract cannot be considered as indemnity contract. In fact, this reminds me of this wonderful film OMG. If you haven't seen, please do watch. You will get to know a lot about the indemnity contract. So it's slightly based on this concept only. A contract of guarantee, on the other hand, is a contract to perform the promise or discharge the liability of a third person in case of his default. Okay, if that person doesn't do, I'll make sure I will do that. This is the contract of guarantee. Perform the promise or discharge the liability of a third person. If he doesn't pay you, I'll make sure the money reaches you somehow. The person who gives the guarantee is called the surety. So you are giving a surety, or you are giving assurance basically. That's why it's called surety. So let's say there are three parties, A, B and C. B has borrowed money from A. Now it has to be repaid to A, but A is not fully trusting B. So C, whom A knows, is giving assurance to A, telling him, see, look boss, if B doesn't repay, I will repay. Don't worry about that. So in such a circumstance, we say it's a contract of guarantee. And who is the surety here? C is the surety. So who is the principal debtor? The principal debtor is A, because he is the one who is supposed to receive the money. Then what about B? B is the creditor. Okay. Oh, sorry, I think I mixed it up. B is the principal debtor and A is the surety, because we owe money to A, no? Creditor is the person to whom we owe money. So A becomes our creditor and B becomes our debtor, because he is the one who owes money to A, and C becomes our surety. B has borrowed money from A and C is giving A the guarantee. So this is the contract of guarantee. Let's move on. Again, same example is given here, similar. Next. Okay, they have given distinctions between contract of indemnity and contract of guarantee. In case of contract of indemnity, there are only two parties. In case of guarantee, there are three parties. So who are the two parties? Indemnifier and indemnified. The one who is giving the assurance and the one who is getting the assurance. Whereas in case of contract of guarantee, there is the principal debtor, the person on whom guarantee is given, creditor to whom the assurance is given, and the party who is giving the assurance, surety. In contract of indemnity, the liability of the indemnifier is primary. He is the one who is supposed to fulfill the promise. Whereas here, the liability of surety is secondary, meaning surety may have assured, but his liability is not primary. His liability will come into picture only if there is default by the principal debtor. If the principal debtor defaults on payment or whatever assurance he had given, in such a circumstance, the surety will come into picture. Until then, he will not come into picture. So therefore, we call it secondary liability. The indemnifier need not necessarily act at the request of the debtor. So the moment they get to know that there is something, so then they will definitely do it. So they don't have to act upon the request. Whereas here, the surety gives guarantee only at the request of the principal debtor, meaning the principal debtor has to request, saying, please give me the guarantee or give guarantee on behalf of me. So it is moving at the request of principal debtor. In case of the indemnity, the possibility of any loss happening is the only contingency against which the indemnifier undertakes to indemnify. Basically, so here, what is the problem? If at all there is any loss caused due to some unforeseen event, then we will indemnify you. That's all. There is no other thing. So only if in the event of such unforeseen event or loss, the indemnifier will come into picture. Otherwise, the indemnifier will not do anything. It's like insurance contract. We pay insurance, vehicle insurance every year. Does that mean that every year we'll get back some amount in return? No, of course not. The insurance company has told us only in the event of some accident or something else, we will make sure that you are indemnified. Otherwise, nothing doing. Okay. Adarsh says good morning. Adarsh, very good morning. Next. In case of guarantee, there is an existing debt. This is one of the principal differences. See, in case of guarantee, there is no such eventuality. You have already borrowed money from the creditor. Once you have borrowed money from the creditor, you are bound to make the payment. There is no such unforeseen event here. So the contract is between, the principal contract is between creditor and debtor. So the debtor is supposed to make the payment. That's it. Surety will come into picture only if there is default. Otherwise, there is this liability always in case of guarantee. In indemnity, the indemnifier cannot sue third parties in his own name unless there be assignment. He must sue in the name of the indemnified. So whoever has been indemnified, for example, if in case of insurance companies, let's say due to some unforeseen event, the company had to indemnify the insured. So, and now they realize that this event happened because of someone else's negligence. Then they cannot sue on their own, but they will have to sue in the name of indemnified. Okay, so that is there. Whereas in case of guarantee, the surety on payment of the debt, when the principal debtor has failed to pay, is entitled to proceed against the principal debtor in his own right. So this is interesting. It's like in our previous example, if you look at it, A had lent money to B. B had to pay the money to A. Let's assume B did not pay. There was this surety C. Now surety had to pay A because B defaulted. Now C has every right to proceed against B. So he can do that. That is the difference here. Anyway, let's move on to law of agency. Let's take a break of a minute and then we'll continue. Welcome back. Now let us look at law of agency. An agent is a person who is employed to bring his principal into contractual relations with third parties. Okay. As the definition indicates, agent is a mere connecting link between the principal and a third party. But during the period that an agent is acting for his principal, he is clothed with the capacity of his principal. So very neatly explained as to what is the duty or what is the feature of agency. Let's say A is a movie actor. Now he deals with his producers only through his agent, or he deals with his endorsements only through his agent. So now whose what is that duty it is to make sure that A has been represented properly? It is the agent's duty. So he will enter into contracts on behalf of A, because he is acting on behalf of A, and A need not have to enter into every contract, or rather the initiation will be done by agent. Finally the contract might be entered by A. So this is something which is very common in the entertainment industry, wherein there will be an agent for the actor or whoever it is. Even these days, even the stand-up comedians, they will all have their own agents. These agents negotiate on behalf of the actors or whoever that person is. And in case of books also, the authors will be represented by their agents. So those agents will hopefully try to get the best for their principals. The principals are those on whose behalf these agents are entering into negotiations. Okay. He is a mere connecting link between the principal and a third party. For example, if some producer is trying to get this actor's dates for a movie, then first he will obviously approach the agent. So the agent will check with the actual, this principal, and in fact he doesn't even have to check. They will know whether the dates are there or not, or blocked. So whether script, if there is any script, they will pass on the script to the principal. The principal will not at all get into a picture initially. Once all those things are done by the agent on behalf of the principal, only then they will come into picture. So that is the thing. A contract of agency may be express or implied, again the same thing, but consideration is not an essential element in this contract. This is very important, because if you remember the exceptions to the principle, no consideration, no contract, This was one of the exceptions, that is the law of agency. If you are an agent of someone and there is some principal, or if you are the principal and if you have an agent, consideration need not be paid. I don't know why this has been given this status of exception, but that is the way it is. Okay. So now let us look at what they have said. Express agency. A contract of agency may be made orally or in writing. Okay. Again, express or implied is something which is there for everything. They don't have to specifically mention that it is there, here, etc. The usual form of written contract of agency is the power of attorney, which gives him the authority to act on behalf of the principal. That's what I told earlier. So now the agent will get into contract sometimes if he has that power of attorney. Power of attorney meaning, so I am not here, you act on my behalf. You will represent me in this cases, and if at all you have to do anything, you go ahead and do on my behalf in my absence. So that is the authority which is given to the agent. So in such a case, it will obviously be written. Otherwise, no one will accept such oral claim by the agent. Implied agency. That means through the conduct of parties, a situation may arise wherein we say there is agency. There is this agency by estoppel, wherein if someone is telling you, or let's say I will give you an example. A, B and C. Three people were there, and A and B are friends, and B casually mentions to C that B is the agent of A. B is acting on behalf of A in his business matters, wherein it is not the case. It is not the case at all factually. He is lying, but A keeps silent. A doesn't say anything at all. Now, C would definitely believe B because A, who was also present, did not raise any objection. Now, A has, by his implied action, become the principal, and B has become the agent. So this is called agency by estoppel. Wife as agent. Where a husband and wife are living together, the wife is presumed to have her husband's authority to pledge his credit for the purchase of necessaries of life suitable to their standard of living. So very clearly it is limiting the assumption wherein they say pledge his credit for the purchase of necessities only, not for anything else, and also suitable to their standard of living. So based on this, the wife can be considered as an agent, but the husband will not be liable if he can prove that he had expressly warned the tradesman not to supply goods on credit. So if husband has realized that his wife is spending too much, or the vice versa, if the wife has realized that the husband is spending too much, and if they have already told the other guy, the shopkeeper, that don't sell it to my spouse because they have been borrowing too much, more than what is necessary and more than our standard of living. So he had warned that person. In spite of such a warning, the tradesman had supplied the goods to their spouse. In that case, husband or the wife will not be liable. He had expressly forbidden the wife to pledge his credit, or if he had told the wife, don't take credit in my name, or if wife had told husband, don't take credit in my name. His wife was already sufficiently supplied with the articles in question, meaning when she already had items, the same items which she wanted to purchase again, then there is no point in taking the credit. Or she was given sufficient allowance, meaning you have been provided money. On top of that, why do you need to take credit in my name when there is enough money with you already? So this is the agency of necessity. In certain circumstances, a person who has been entrusted with another's property may have to incur unauthorized expenses to protect or preserve. This is something which is often seen if you are managing someone else's property, because you never know what are the unforeseen expenses you may have to end up bearing. All of a sudden the electricity might not be working, or rather, let's say the fans are not working, the bulbs are not working, the tap is not working, there is some leakage of water somewhere. So now you have been entrusted to take care of the property, but when they say take care of the property, you should make sure these things are also working properly, no? So you will spend. You can't ask for that person's permission. That fellow is somewhere unreachable. So now what do? You go ahead and spend money to get the tap fixed, the leakage stopped, maybe get the bulbs and other plug points repaired. Now the other person who is the owner, then they cannot say that I didn't give you express permission to actually repair all this. No, it was required because of the circumstance. In that case, the person who has done that, all that has spent money, they can definitely recover. A wife deserted by her husband and thus forced to live separate from him can pledge her husband's credit to buy all necessaries of life according to the position of the husband, even against his wishes. This is interesting. So, wife deserted by her doesn't mean the wife husband has left her and gone elsewhere. Now, if that is the case, the wife was dependent on husband. Let's assume in this case. So, what she can do is she can simply pledge his credit, saying she can buy in the name of husband, and he will have to definitely clear the liability, even though it is against his wishes. Even though if he has told, don't pledge in my name, because he has deserted her. So, the law provides her the protection through this. What is it? Provision. Agency by ratification. This is also interesting. Wherein what happens sometimes, you would not have given powers to the agent, certain powers at least. So, but based on the circumstances, the agent might have acted beyond their powers. So, whatever was their authority, they may have acted beyond their authority. Then you come back, you see what the agent has done. You realize that this is something which was necessitated based on the circumstance. Whatever agent has done, he has done properly only, because if he had not done, or if she had not done, so things would have gone haywire. So what do? You ratify it later on, saying you did not have the power to do this earlier, but now I am giving the ratification, meaning I am making sure that it is authorized now. So whatever has happened earlier, I deem it to be authorized. So that is called agency by ratification. Okay, but there are few conditions to be satisfied. Let us look at that. The agent must expressly contract as agent for principal who is in existence and competent to contract. So there must be an express contract. The principal must be competent to contract not only at the time of agent, at the time the agent acted, but also when he ratified the agent's act. So basically, he should not be of insane mind. He should not be expressly debarred by contract or debarred from entering into contract by any Indian law. And finally, he should be a major. So if all these things are satisfied, then you can say it can be ratified. The principal at the time of ratification has full knowledge of the material facts. So when you come back, when the agent has acted beyond authority, when you see that the agent has acted beyond authority, you should have the full knowledge of the facts. It's not as if the agent has hidden few things and told you only few things which is music to ears. Okay. Anyway, ratification cannot be made so as to subject a third party to damages or terminate any right or interest of a third person. So you cannot ratify in such a manner that someone else's right is affected. So that is not possible. Only lawful acts can be ratified. So the last 2 points are fairly obvious. I won't get into that. So then we have different types of agents: special agent and general agent. Special agent is the one who is appointed to do a specific act. That's all. Let's say I will appoint you as my agent for this particular event. That's it. So in that event, or when you are organizing that event, you will have a right to represent me and do based on the authority which I have given you. Beyond that, you are not my agent. If tomorrow, if you come to my workplace and then say I am your agent, no, I won't agree with that. You are my agent only for the specific event. You organize that event on my behalf. You spend money on my behalf. Why? Because you have been appointed as an agent for that only. Whereas in case of a general agent, is appointed to do anything with the authority, like some kind of a secretary, wherein you appoint someone who will take care of your duty. Whatever that official duties are. So in your stead. So in such cases, it will be a general agent. So you don't have to give him or her power every time. So once you give the authority, or once you sanction the authority, or once there is an agreement between the agent and the principal, then that will stand until it has been revoked. That's it. Sub-agent. If the agent appoints someone else as their agent, then they become the sub-agent. So the sub-agent is not directly responsible to the principal except for fraud and willful wrong. If he willfully does something wrong, then they are liable to the principal. Okay. So otherwise no. So the sub-agent will be responsible to the original agent, because they will have that agency relationship, between the original agent and the sub-agent. So therefore they are not liable. Sub-agents are principally not liable to the who's that? Directly not liable to the principal. Okay. Next, there are other types of agents as well. Mercantile agents, having in the customary course of business as such agent authority, either to sell goods or consign goods for the purpose of sale. Basically, the authority is only to sell goods or consign goods for the purpose of sale, or to buy goods, or to raise money on security of goods. Very limited right. So that's why it's called mercantile, only with respect to the trade. Now let's look at factors. Factor is a mercantile agent employed to sell goods which have been placed in his possession or contract to buy goods for his principal. Again, very limited authority. So they do not have any authority beyond that. Broker. Broker is a mercantile agent whose ordinary course of business is to make contracts with other parties for the sale and purchase of goods and securities, of which is not entrusted with possession for a commission called brokerage. So his duty is only to make sure that the principal gets contracts with respect to sale or purchase, and he will not be in possession of the physical goods or whatever goods the agent is dealing with or the principal is dealing with. Then we have del credar agent, who is in consideration for extra remuneration, and instead he guarantees he guarantees his principal that the purchasers who buy on credit will pay the goods they take. So this is something which we see in consignment, wherein we say the goods have been consigned to the agent. The agent is supposed to sell those goods on behalf of the principal. The principal has told agent, don't give the goods, or rather don't sell the goods on credit. But the agent tells principal, don't worry about that. I will take the risk. If I am able to get more sales beyond what you normally get, I will get the commission. At the same time, I also take the risk of credit sale with respect to certain people. So in that case, we call them del credar agents. Auctioneer. So auctioneer is also an agent temporarily, because he is dealing on behalf of the others. Partners, we have already seen, I guess. Every partner is an agent of the firm and of his co-partners for the purpose of business. When he is the agent, the others will become principal. So they will also get, when they act like agents, they become the agents and the others will be principals. And banker. So what we do in case of banker, we keep our money with the bank. So they will act as an agent. So in addition, the banker is an agent of his customer when he buys or sells securities, collects checks, dividends, because they do all these things. They collect dividend on our behalf. They make the payment to mutual funds on our behalf. They make the payment to someone else on our behalf. So all these things they do on the behalf of the customer. So they become the, agents. Okay, couple of more pages, then we'll be done with this lesson. Let's look at the duties of agent. In agent's duties towards his principal, okay, these are all duties which are fairly self-explanatory. I won't get into this because you can easily read that and understand. Again, there are certain rights, so just please go through that. It's like we have already seen these things in different forms. I don't want to repeat, but please go through that once. It's easy to understand, not that difficult. And when it comes to e-contracts, they are not very different from other contracts. So here also section 10 elements must be present. If section 10 elements are present, then we say e-contracts are also as good as any other contract. If you look at this, it is nothing but section 10 elements only. So there's not much of a difference. So maybe perhaps you will send an offer through email and the other person accepts the offer through the email, and then what? Yeah, it goes on like that. But the rest of the things stands as it is. So there is no doubt about that. Anyway, let's move on. We are done with what is it? Contract Act. So let's move to company law. So this is lesson 4. I'll be taking up the other lessons in the next class. So let's see what exactly it is. The word company is derived from the Latin word cum, with or together. Panis means bread. So, and it originally referred to an association of persons who took their meals together. That's interesting. In the leisurely past, merchants took advantage of festive gatherings to discuss business matters. So they did not have any other time to discuss business matters. So they did that only during festivals. Nowadays, the business matters have become more complicated and cannot be discussed at length at festive gatherings. So you can't do that now, they say, and therefore it's done formally these days. So, but whatever it is, that's how the word was derived. That is from the Latin word cum, that means together, and bread, panis, wherein they used to do this. So now, of course, we have companies wherein we say many people come together and start a company. So when they realize that partnership might not be sufficient for them, because that is the next best alternative, so there is a limit. So therefore we don't want to have any limit, because we need to raise a lot of money. Unless it's a company, we won't be able to raise money. So therefore we want to start a company. So they may start a company. In fact, even the Britishers came to India as a company, that is the East India Company. So of course they came like traders or as traders, then went on to plunder the nation for 300 years. In popular parlance, that means in popular mostly, a company denotes an association of like-minded persons formed for the purpose of carrying on some business or undertaking. So company need not mean that there'll be too many people. Sometimes company can have only 2 people. Even then it will be a company. Or if you think of one person company, which is relatively recent invent, so in that case only one person can also be considered as company. So that is there. So it is called a body corporate. Why is this called a body corporate? Because company does not have a natural existence. A person will have a natural existence. You are born, as soon as you are born, you are considered as a person. Whereas in case of a company, it cannot be considered as a person, or rather incorporated, until it is statutorily incorporated. For example, a company will come into existence only after a certificate of incorporation is given to it by the registrar of companies. Once that certificate is given, the company has come into existence. So just like any natural person dies a natural death and he will no longer be a person or living being, in case of company it is not the case. In case of company, there is no question of natural death at all, because company is a non-living being. Even if all the members of the company die also, we say no, the company has not died. A company can only die the way it has taken birth. How does it take birth? It takes birth through incorporation, meaning legally. Likewise, if it has to be wound up, it has to be done so legally only, no other way. So there is something which you have to understand. Okay. So we have different characteristics of a company. So which are the characteristics? Of course, we have seen this corporate personality, limited liability, very important characteristics, meaning in case of partnership, your liability is never limited, because you may have invested, let's say, 10 lakh rupees. The firm might have incurred debt of 15 lakh rupees. Now you cannot tell, I've already invested 10 lakh rupees. You take care of my or rather the debt of the firm through that money. Don't ask me anything else. No. As a partner, your liability is unlimited. Whereas in case of a company, if you are a shareholder, your liability is always limited to the extent of unpaid capital. That means if the share price is 10 and they have issued and asked you to pay 10, let's say 10 rupees, and you have only paid 5 rupees so far on the 1000 shares which you have, the company at best can only ask you to pay the remaining amount which is due to it. So out of 10, how much have you paid? 5. So remaining 5 you may pay towards those 1000 shares. That's all. Then we have perpetual succession. What is this perpetual succession? It only means that the company will live forever until you close it or wind up legally. We already saw that. Separate property. This is interesting. A company can buy and hold property in its own name, whereas a firm cannot do that. So company has that right. They can definitely buy property in the name of company itself. Transferability of shares. This is one of the most flexible options of a company. Wherein how do you determine the management of a company? Usually the ones who have majority shares manage the company. At least in India, that is how it is. And one of the interesting features is, if tomorrow I want to retire from my own company, I feel like I have done enough, or I want to move to some other idea, I will sell this to someone else who will have the interest to take care of this. Then what can I do? I can simply sell, or rather transfer the shares to such a person, and they will be able to take care of the company later on. Then we have capacity to sue and be sued. This is obvious. Contractual rights, limitation of action, separate management. So separate management in the sense, the board of directors basically are the ones who manage the company. It need not always be the owners. It could be anyone else other than owners, in the sense the majority stakeholders. What I mean by owners is that, because there is no such thing as owner in case of a company. Voluntary association of persons for profit. That is also obvious. I won't get into that. Termination of existence. We have seen how to terminate the existence in case of a company. These are the characteristics of a company. So we'll stop here. We'll continue that in the next class. Thank you for joining. So before we wind up, let me just take you to our website, excelacademy.com, so that you will know. So this is our website. So you can register there using your Google or Facebook ID. As you can see, there is an app as well. If you use an Android phone, you can download the app from the Play Store. Then there are various courses. So all these courses are available with respective sample videos. You don't have to buy the course outright. You watch the video. If you are happy with it, of course you can buy the module. And of course, this is one of the important things now, mock tests. So you'll have to take up mock tests, because that is something which is very important, especially for an executive or professional. So that will give you an idea as to the kind of exam, or rather it will give you that experience of facing the exam. You won't feel out of sea when you're actually appearing in the final exam. So that is the thing. Anyway, so please do register on our website and download the app if you have an Android phone, and make use of the notes, quizzes and mock tests. Thank you. See you tomorrow at 7:30 once again. Bye bye.